Good morning, and thank you so much for being here. In regard to this rather important issue, I am Chair Assemblyman Tom Amiano. I'm joined by my esteemed colleague, Assemblymember Yamada, and we will soon be joined by Assemblymember Gilmore. And they will be the, I think, remaining contingent of the members today. And we are here to discuss the impact of SB 40 on Cunningham, the Cunningham decision. Before I make my remarks, Assemblywoman Yamada, do you have any comments you'd like to make?
I'm very pleased to join you today and look forward to hearing the discussion.
Yes, same here. Thank you very much. And wanted to again welcome you to the Public Safety Oversight Hearing examining the effects of SB 40 after the Supreme Court ruling of Cunningham versus California. In 2007, the court ruled that California's determinate sentencing law was unconstitutional and violated the Sixth Amendment, which is the right to jury trial. At that time, SB 40 was quickly enacted to preserve stability in the trial courts, enacted to eliminate the presumption for the middle term in the sentencing triad. It authorized the lower court, in its sound discretion, to choose a sentence, but state its reasons on the record. SB 40 also included a sunset date and reporting requirements on CDCR and the Judicial Council in order to ensure that this solution would be reviewed with a particular eye on how it might affect our ongoing prison overcrowding problem. Today we will review how SB 40 has worked in the lower courts over the past 3 years and discuss alternative proposals. First, Paul Galawatsky of the Legislative Analyst Office will briefly explain the history of determinate sentencing in California, explain the court's ruling in Cunningham, and explain how SB 40 addressed that ruling. Second, Darby Kernan of the California Department of Corrections and Rehabilitation will present the data called for in SB 40 and explain how it affected, if at all, the number of defendants sentenced to the upper term. The third panel will review how SB 40 is currently working in the trial courts. Retired Placer County Judge Robert Cousins will testify as to how judges are educated about this change in the law, and representatives from the district attorney and defense community will share their experiences with SB 40. The last panel of prosecutors and defense attorneys will discuss the merits of alternative proposals, including a requirement that all factors used to impose the upper term be proven to a jury, and the development of a sentencing commission. The goal of this hearing is to examine the effects of SB 40 and any alternative proposals before deciding in the new legislative year to eliminate the sunset date and make SB 40 a permanent solution. So we would like to begin, and first welcome Assemblyman Gilmore. Good morning, sir. And would you have any comments you'd like to make? Sorry to get you on your feet here.
Just happy to be here.
Okay, I can tell. We're happy to have you. So let's begin with our first panel. Mr. Galawatsky from the Legislative Office. And why don't you pronounce your name for us? So, thank you very much. Mr. Lao, and I apologize for mangling your name. If you want to begin.
Sure, I'll start. The sergeant just distributed a handout from which I'll be speaking today. Flip to the first page of the handout. I'll provide you with a little bit of background on criminal sentencing in California. There's sort of two basic types of sentencing in California. The first is indeterminate sentencing. And with indeterminate sentencing, you get a range, an indefinite range of time to serve. So for example, 25 would be an indeterminate sentence. And in order to get released from prison, there's four questions. Prior to 1977, all felonies in California were indeterminately sentenced. And then in 1977, we switched over, and now most felonies are punished with determinate sentencing that I'll talk about in a minute. Right now, the state uses indeterminate sentencing generally for the most serious crimes, such as first-degree murder, as well as repeat offenders, the three strikes law has a 25 years to life penalty for the third strike. Right now, about 20% of state inmates are currently serving an indeterminate sentence. The other basic type of sentence that we have is called determinate sentencing. And with determinate sentencing, a convicted felon would receive a fixed prison term and would not appear before a parole board in order to be released from prison. So, for example, right now in California, we use what is called a triad for determinate sentences. And this means that there are 3 possible prison terms. So, for example, first-degree burglary is punishable by 2, 4, or 6 years in prison. And about 77% of state inmates are currently in prison serving a determinate sentencing. So those are the 2 basic types of criminal sentences in California. Now, if you flip to the next page, I'll talk about the Cunningham case and how that affected California's determinate sentencing law. Cunningham was convicted in California of the crime of continuous sexual abuse of a child under the age of 14. And under California's determinate sentencing law, as I mentioned, there would be 3 possible prison terms, and that was 6, 12, or 16 years. Now, at that time, under California law, the judge was required to impose the middle term, which in this case would be 12 years, unless there were aggravating or mitigating circumstances. And under California court rules, it was left up to the judge to determine if there were aggravating or mitigating circumstances. So in the Cunningham case, the judge found that there were 6 aggravating circumstances, 1 mitigating circumstance, and concluded that the aggravating circumstances outweighed the mitigating one and sentenced Cunningham to the upper term, which was 16 years in prison. Cunningham appealed this sentence first in state court, and later it eventually reached the U.S. Supreme Court. And the basic issue here is the Sixth Amendment of the U.S. Constitution's guarantee to a trial by jury. So if you flip to the 3rd page of the handout, I'll go through what the Supreme Court found in the case. The Supreme Court found that the 16-year sentence, which was the upper term, did violate the Sixth Amendment right in the U.S. Constitution to a trial by jury. And this was because, and this was consistent with prior court rulings, it wasn't necessarily particular to California, but it found that the sentence for a criminal offender must be based on the findings of a jury rather than a judge. And as I mentioned previously, under California law, the presumptive term was the middle term, and then it was left up to the judge to determine the facts that would make it either an upper term or a lower term. So in this case, the court found that this was unconstitutional and that the jury would have had to make those findings in order to elevate the sentence above what was the presumptive middle term. The Supreme Court left it up to the state to decide how to fix its determinate sentencing law. It noted that other states allowed judges more discretion to impose a term within a statutory range, or some other states also had the jury determine if there are aggravating or mitigating circumstances in order to address the Sixth Amendment issue. So if you turn to the last page of the handout, I'll walk you through what California has done in order to respond to the Supreme Court decision. 2 months after it was issued, the legislature enacted SB 40. This was in March 2007, and it was enacted on an urgency basis to respond to the Supreme Court decision. It was intended to provide a temporary response to the ruling while California sentencing laws were being reviewed. And what SB 40 did was it basically changed California law to say that when there are 3 possible terms of imprisonment, that the choice of the appropriate term would rest within the sound discretion of the court. So the main difference is, whereas before the presumptive term was the middle term, now the court has discretion amongst the 3 terms to impose whichever term it wants. SB 40 also required the California Department of Corrections and Rehabilitation, CDCR, to collect data on the number of felons admitted to state prison with an upper term sentence. And the reason for that was just to see if this would sort of change the number of offenders coming to prison with an upper term when the court had more discretion to impose that. SB 40 also required the Judicial Council to report to the legislature on its implementation of the sentencing law change. SB 40 contained a sunset date of January 1st, 2009. This has been extended twice, most recently by AB 2263 by Assemblymember Yamada, and that has set the current sunset date to January 1st, 2012, after which time it would revert back to the previous determinate sentencing law, which was found unconstitutional.
Okay, thank you very much. What I gather is that the Cunningham case, the Supreme Court really left it extremely vague as to what California should or could do.
The Supreme Court left it entirely up to the state to determine how to fix its sentencing law. As I mentioned, other states have had similar issues. The Cunningham case was not the first one, so other states have taken different approaches, but the court left it up to the state to decide how to do it.
And the other states don't have 3 strikes, I believe, too, and I imagine that has an impact on all this.
I believe some other states have similar 3 strikes laws, but not all. Yeah.
Okay. All right. Well, listen, thank you very much. Any questions or comments from
Just did have one. Thank you, Mr. Chairman. I'm glad you mentioned the 3 strikes issue. We also have seen other, recent legislation such as Chelsea's Law and so forth that adds to some measure of inflexibility for certain offenses, obviously. But in the context of where you sit and what you see as the whole set, not just Cunningham, but the whole set of sentencing requirements that California has operated under, without this discussion today, I don't know if we're going to be able to look at sentencing as a whole, as a holistic issue, rather than just this particular dynamic. And what would be your response or recommendation to that?
The Cunningham case applied specifically to determinate sentencing. So the indeterminate sentences, like 25 years to life, weren't really at issue in the Cunningham case. However, this would be a choice really up to the legislature if they want to sort of revisit. As I mentioned, we switched to determinate sentencing back in 1977. Different states have different approaches. You could use this opportunity to review as a whole California sentencing system, or just address this specific issue with Cunningham, which would be more with what to do about the determinate sentencing law.
Yeah, well, it is the chair's hope anyway that we really do tackle sentencing holistically with a sentencing commission. And yes, and Mr. Gilmore.
Thank you. Just a quick question: in the LAO, in your analysis, did you look at to see the number of did the increase in the sentencing on the upper end? Did we see an increase in the upper end of sentencing?
Yeah, CDCR's been collecting data on that. We haven't done sort of a formal analysis of the data they've collected, but if you just look at the raw numbers, there isn't really it's sort of fluctuated a little, but not greatly from year to year. So there isn't an obvious trend, but we'd probably have to study it a little more in detail to say definitively. But if you just look at the raw numbers, it's kind of just fluctuated a little since 2000.
Actually, didn't the percentage actually go down?
In 2007, it did go down. Then it increased slightly a little after that each year.
Okay. The next panel will be addressing that issue too in more depth. I want to thank you very much. Thank you. And if we could have our next panel, please. And this is Darby Kerman, CDCR.
Hi.
Good morning.
Thank you. Mr. Chair and members, thank you so much. I also have Jay Atkinson, Chief of Offender Information Services branch within the Office of Research for CDCR. So while I can give you an overall explanation of the numbers, any details, Jay can go into more detail for you.
Okay, let me tell you before you start, what I'm particularly interested in is an explanation about how you gathered the number of offenders sentenced to the upper term, and then how did you account for offenders with multiple terms. And lastly, your data seems to indicate that in some counties, upper term commitments rose steadily, and in other counties there was significant decrease. And just wanted to get your opinion on why do you think those discrepancies happen from one county to another?
Well, then I'm really glad I brought Jay. Well, let me first talk about the data that you guys have in your handout is based on offenders who have an upper and a lower and or a lower offense. So you could have someone counted for an upper, and if they also had a lower offense and sentenced to a lower offense, that would also be included. We do have other data that we ran where it was where the principal offense was an upper and the principal offense was a lower. So they were separated out. But there is no real distinction between the two. It may be changed by 50 to 25 people per year, an upper and lower, but it didn't change drastically based on if it was one of the principal, based on if they had an upper and a lower. So do you want us to walk through the numbers, or do you want us just to talk about how we got the numbers?
Why don't you do both?
Okay, so we'll go off the books, the numbers that you have in your handout, which to start in 2004, after SB 40 was passed, we started collecting this data. And so what you see in 2004 is the lower term for males was 33,064, and for females, 4,558. The upper term was 9,474 and for males and 870 for females. In 2005, or just let me just conclude though also, so total emissions in that year were 64,000. One of the difference of why that won't completely add up is because people could be added twice here because they have more than one offense. Also, they may not, this does not include the middle term or the indeterminate, so just to clarify on that. In 2005, the numbers increased slightly for males in the lower term. It was 35,102, and for females it was 4,907. Again, a slight increase. 2006, the lower term increased again for males 35,858, and for females 5,139, and for the upper term 9,455, and for males, and 859 for females. Then it dropped down slightly in 2007. So in 2007, lower term for males was 35,383, and for females 5,011, and for upper term 7,612, and for males, and then for females 728. Again, there was a drop or an increase. It increased, I guess, for some, and for the males lowered in 2008. So the lower term for males in 2008 went down slightly to 34,434, but for females went up slightly to 5,198. And then for the upper term, it increased for both, with the males at 8,962 and the females 856. 2009, a drop occurred for some, and then increased as well for others. So the lower term dropped for the males in 2009 to 32,880, and for females as well for the lower term it dropped to 4,546.
Yeah, so I think it's probably important just to address that, especially that year. This is when we were also ordered to take efforts to mitigate the population. So you had both things happening at the same time. Yeah.
Correct.
Yeah.
And then in the upper term also increased for the males but decreased for the women in 2009. So for males it was 9,213 and 832 for the female. And then for 2010, we only have half a year collected, reflected in these numbers, and I think it ends up if it was to be consistent, it would probably be, again, maybe a little higher for the males but lower for the females in the lower sentencing, and maybe higher for the males in the upper term, but consistent with an upper term for the women too as an increase. But when we went through the data and we were talking about the offenses, also in your packet, 2 pages behind this first sheet is an example of what we used. And this is one offender, so his CDC number is consistent. However, he has 4 cases, 4 separate cases. And then if you go to the base level, there you can see the L is for the lower and U is for the upper and the M is for the middle. Also, and you go to the sentence type at the end, he's a lifer. So again, it is very difficult for us to draw any conclusions that could be valid, whether the sentencing, from our data, whether it's made any differences, because it's fluctuated.
Do they serve consecutively? Do they serve concurrently?
Yes.
And by lifers, that means no parole?
Yes, correct.
No, it would be W.
Oh, life
If it was
without.
life without parole, it would have been the send type would have been a W for a
LOW,
WAP.
yeah.
So this individual would be eligible for parole potentially at some point.
Many times, maybe.
Mr. Chairman, may I just ask one sort of foundational question for me to try to understand this? When you are comparing, going back to the first page when we went through the years 2004 to 2010, and we are looking at these very global numbers, could you explain to me how we can actually compare year to year, since these are all discrete events? These are not duplicated counts in any way, or they are in some cases duplicated counts? Is that what you said?
They are duplicated counts.
They are
because people, as I showed on here, could have an upper and a lower term.
Okay, but not all are duplicated counts.
Not all, no.
Okay, so I mean, my foundational question is, if we are here today to review the statistics to determine whether the conduct or behavior in sentencing has been altered given the current framework, I'm not sure how much confidence I can have, not in what you're doing, but in the data itself, because you can't. It's almost like comparing apples to oranges from year to year. Would that be correct?
In some ways, although I want to add that we did do a run where we looked at the principal offense. So if the principal offense was an upper term or the principal offense was a lower term, we did do that. And the data that we got from that, the numbers don't change too drastically. So while there could be duplicates in here, it's the numbers changed maybe by 50 or 60 to 75 numbers in each year when you single it out. Yeah. But Jay might have more information to explain.
No, I think that basically you clarified it pretty good.
But we agree. We really can't draw any good distinctions about whether you can see it. We did provide the committee with individual counties so that you can look at how a county, San Francisco versus Riverside, might do that. But again, it varies.
Thank you. Just as an observation, I think it's interesting to note that in our public safety committee hearings, we oftentimes talk about people being sentenced and are overcrowding in prison. But look at this individual here. He's been convicted 5 times of armed robbery, 5 times, and still eligible for parole. Amazing.
Well, again, when I say potentially eligible for parole, it just means that he's not life without.
Right. So he could be denied at his parole hearings.
But one last clarification, again, this is Jay with the CDCR. Even when we looked at the controlling offense, the principal offense, it's of each case. So this individual still has 4 cases. So no matter how we try to capture the data, it's going to be really difficult to try and get any value out of it.
All right, you want to continue?
Thank you.
All right, and moving right along, Our next panel is an examination of the status quo, and if we can have Mr. Cousins, Superior Court of Placer County, retired, Garrick Byers, Office of Public Defender, Fresno County, and Jacqueline Lacey, Los Angeles County District Attorney's Office, and Stephen Munkelt, Law Offices of Stephen Munkelt. And Judge, if you...
Mr. Chairman, members of the committee, thank you for this opportunity to address you and give comments on behalf of the Judicial Council and the judiciary. As a point of perspective, I think it might be useful just to point out that I've been on the bench about 34 years now, sitting mostly in the criminal arena. I've written 2 books and working now on a third, all primarily dealing with felony sentencing. And for the last 15 years, I've taught at the Judicial College, so the entry-level judges are inflicted with basic felony sentencing from me, so I've probably touched virtually every young judge as he or she enters the system. So I do have a perspective on sentencing. I've been asked to comment on how judges are trained on sentencing, and we have given you a handout that kind of explains some of the process. Our objective, of course, is balance, perspective, and fairness. So that absolutely has to be the case. This is an individual decision. It's an individual defendant. Notwithstanding feelings of the community or the state, every individual defendant is entitled to individual consideration. So we try to stress that. We start with a discussion of the objectives of the criminal sentence, and that's your first slide that you have there. We go through those elements and others, and we discuss them, pointing out why we are doing this, what are we trying to accomplish. Then we move to the actual sentencing process itself, and what I have taught over the years, and it seems to have resonated with the judges, is that we try to start looking at people on a spectrum. That's the only way you can bring some sense to all of this. So I asked them to ask themselves, is this the best defendant you've seen in the world or the worst defendant? Or is this the most serious case or the least serious case? And hopefully with these perspectives, somewhere they will fit on a continuum. And that continuum then should translate into some form of a sentence. We look at the factors in mitigation and aggravation. That's the next slide. That's a summary. It's taken from the California Rules of Court, and I've attached the full set of rules, both the aggravating and mitigating circumstances, in the last 3 pages of your handout. We talk about these factors. We run hypotheticals. We talk about them in class. We have one judge contrast him or herself with another judge and talk about the reasons why he or she picked a particular sentence. And out of this process, judges begin to get a perspective so that everyone doesn't fit in the maximum term and everyone doesn't fit in the low term, but they begin to get a sense of perspective. And what I stress through all of this is that a judge who is proportionate and in balance is a fair judge, and that judge maintains his or her credibility. And that's ultimately, in terms of our survival, we need to have. We need to have credibility with the bench and the bar, and that is what we strive to do through the sentencing process. I want to emphasize that all of this class has been taught in the same way both pre and post SB 40. Because ultimately the factors have not changed. We used the rules of court before, and we used the rules of court after. Now, in terms of the basic sentencing process after SB 40, one thing I would hope the committee would bear in mind is that we are probably dealing with only 15% or less of the criminal population that we come in contact with, the felony population. That's not even counting the millions of people who come before us in misdemeanor sentencing, where Cunningham has absolutely no play at all. Most of the people are granted probation. Cunningham does not have any bearing on any of that. It only becomes relevant when we start talking about a state prison sentence. And as was commented on earlier, the only thing that really changed in terms of the process was taking away the presumption that existed for the middle term. We no longer are required to look to a presumption, but we are given the option of imposing any appropriate sentence. But again, we are looking at the rules of court. I think the statistics that have been presented so far bear our anecdotal feeling about this is that nothing much has changed since SB 40. Judges want to impose a proper sentence. If the defendant has earned an upper term, he or she will get an upper term. If they have earned a lower term, that'll be the term. If it's a middle term, that will be the term. And while the presumption, or the elimination of the presumption changed the process slightly, the outcomes remain the same. Frankly, from the bench standpoint, we favor the discretion that SB 40 accorded us. To the extent that the presumption was restrictive, I think naturally judges feel that we ought to be able to impose the sentence we feel appropriate, given all of the circumstances, and SB 40 does that, and also satisfies, as we've now determined, the problems that the Cunningham case had with the U.S. Supreme Court. I'm happy to respond to any questions if you would like, or move on to the other panelists.
Sure. Before I call in, just a general comment. You know, here in the legislative branch, of course, it's the profile of what the crime is at the time that sometimes influences legislation. For instance, the high profile in and around Chelsea's Law. And I know that judges are supposed to be insulated from that, and I think that's a good idea. But I think in the real world, you know, the press does what it does, and currently in my area in Oakland, we have the case of the officer who shot one of the passengers, and recently he got 2 years, and there's a lot of discussion about that, whether it was appropriate or not, and so there's it depends also, not so much in the courtroom, but in terms of laws that are executed here. You know, the political part is also a reality. I'm not saying it's good or it's bad, but it is something that we have to deal with, which is why I'm very, very supportive of a sentencing commission, so that we could really look at this whole picture. So I thank you very much. I thought this was a very good template, even for the layman, to understand what a judge has to deal with when they're involved in cases that are sometimes controversial. So, and then also the impact of the court orders, you know, to reduce population. Do you think that plays into it from time to time as well?
I think honestly, most judges take the position that we have to sentence considering the rules of court and the person in front of us. While we are obviously concerned about overcrowding and what problems it creates, I don't think we can put much weight on that. You know, it's something that obviously we would like solved, so that whatever sentence is ordered is served fairly and appropriately in an appropriate facility. And we hope that some solution can be you know, created to help ease that.
Or some valid alternative that might satisfy all of it.
Certainly, and I will say that this legislature has directed the Judicial Council to work with the probation departments around California on evidence-based sentencing, and we are in the process now of working with our judges in training them on the concepts, and that is all calculated, as you know, to keep people on probation, to make them succeed on probation so that we don't need to send them to prison on violations. We're very committed to doing that, and in fact tomorrow I'll be meeting with the judges from most of the northern counties here in Sacramento to give them the briefing on that whole process. So we're very committed to that where we can help.
Thank you. I really appreciate your service too. Ms. Yamada, Mr. Gilmore?
Yes, I did have one quick follow-up question. I think what I heard you say is that in general the judicial branch appreciates the flexibility that currently exists.
Yes.
And that would be notwithstanding whether we had Cunningham to begin with or whether we had SB 40 as a response, just in general as officers of the court and stewards of justice, the judicial profession really relies upon that kind of flexibility in order to make the fairest judgment. Would that be correct?
That would be correct. I think to try to give a sense of perspective to that comment, we're dealing with, as you can see, thousands of people in the criminal justice system. Yet in sentencing, we're asked to pick from 3 terms. Mm-hmm. So already we are asked to narrow our focus to 3 possible choices. And the fact that we now have less restrictions in selecting the proper term, that would, in our view, be appropriate, because everybody, again, is an individual. Every case is an individual case. Every victim is in a different situation, and all of that. And to the extent that judges are free to consider all of those factors in each individual case, we would approve that.
And just one other follow-up question, if I may. I don't know whether you're going to be seeing Superior Court Judge Rosenberg from Yolo County tomorrow in this Northern California discussion. He was my predecessor in office at the Yolo County Board of Supervisors, and so had many conversations with him over several years prior to him becoming an officer of the court, and certainly now. But has there been any tracking at all in terms of the choices that judges have related to the decline in rehabilitation programs, I think, that are available? I think we've seen a decline in funding, both internal to CDCR and external on the community over the past few years in particular, that the options that judges may have, and that this is maybe absent the felonies, but just in general, would you say that when judges have other alternatives, that a fair chance at rehabilitation would speak in the future to a reduction in repeat offenses, or the whole issue of if there is a choice for reform and rehabilitation, it's better than prison? And that may be a very hard question to answer, so it's just more philosophy.
We embrace the concept of evidence-based sentencing because that is exactly what it's designed to deal with. Not the people in prison, but people to prevent them from going to prison, because we recognize that the services in prison have not been as best as anybody wants. There have been severe cuts and lots of different reasons for that. The judiciary itself does not track that. That's something that would have to be taken up with the Department of Corrections and Rehabilitation. But in terms of anything that I think you'll find broad appeal to the fact that if there is some alternative locally that judges can take advantage of that works, we will take advantage of it. But that involves two things. First of all, the option to do it, and second of all, the funding to support the programs for it. And we're hoping that the evidence-based sentencing emphasis that the legislature has given us will continue to play out, and that we'll get the legislative support for the programs that are fundamental to the success of that program.
Mr. Gilmore. Thank you so much. Okay, Mr. Byers. And Mr. Byers, I wonder if in your presentation, the question I have would be, what facts have you seen that would elevate a sentence to an upper term?
Okay. First of all, thank you for having me. I really appreciate the committee having me. I'm speaking here on behalf of the California Public Defenders Association. The California Public Defenders Association is the largest organization of criminal defense attorneys in California, and although we began as a Public Defenders Association, we now have many private attorney members. The Public Defenders Association originally, when SB 40 was enacted in 2007, we did not oppose SB 40 because of the legislative intent that this was to be an interim measure while there was a review of sentencing taking place. At that time, there was a Senate bill for a sentencing commission. There was an Assembly bill for a sentencing commission. Governor Schwarzenegger was seeking one in I think it's AB 900, and even the prison guards were contemplating seeking a bill for a sentencing commission. Unfortunately, none of those passed. This hearing today is an important start on a very serious and in-depth examination of the status quo. The information that CPDA has been able to garner about the status quo and the effects of SB 40 do give us concern, and particularly in the area of the aggravated sentences. The DSL, the determinate sentencing law, which originally, of course, required the court to find facts to aggravate or to mitigate a sentence, one of the most important points of the requirement to find facts was that it ensured some uniformity of sentencing, and it ensured, in terms of Judge Cousins talks about evidence-based sentencing, I'm very pleased that the Judicial Council is not moving away from evidence-based sentencing. When it's tied into fact-finding, why, of course, you have a greater degree of certainty. So we're concerned that the discretion may cause an uptick or more than an uptick in aggravated sentences. It may cause some disparities by geographical area, by sex, by ethnicity, by race, by income. There's been very little published so far, very little done. I'm very pleased with this handout that the committee has for this hearing, and in particular, there's many more statistics from the prisons than we have seen before. So far, the prison system, the CDCR, has had to publish on the web aggravated sentences by numbers. And what we have noticed is, from that, is that there has been an uptick in aggravated sentences from the year 2006, which is the last full year before the Cunningham case, and the year 2009, which is the last full year for which figures are available. We've noticed a 1% upturn in aggravated sentences from 14.6% to 15.6%. And you can see this in this chart, which I'll refer to in a few minutes in another context. We don't know if there's a disparity within that. We don't know if in some geographical areas there's a greater uptick than in others. We don't know if there's a greater uptick by income level or by racial or ethnic categories. I see that in the statistics that CDCR has, we have a breakdown by male and female. That's a help. Of course, and you can bet that the Public Defenders Association will be analyzing these. We also have some breakdown by counties, I see, and you can bet we'll be analyzing those. So we'll get some better idea. But the 1% figure of increase gives us concern because this may be just a start. As we still have, of course, most of the judges who are sentencing have been trained under the fact-based system and may be adhering to that more closely than newer judges may. I'm very pleased to hear Judge Cousins say that training hasn't changed. That's a good sign. And I'm very pleased, as I said, to hear about evidence-based sentencing. That's also a good sign. And yet, it has been unhooked. Judges do have, now there's no requirement of fact-finding. There's discretion. So we're concerned that there needs to be a study done of this. And there's been, I might mention also, there's been very few, essentially one or two cases in the, from the appellate courts, published cases considering how SB 40 discretion works. And so we don't yet have appellate guidance for the lower courts and for this committee as well. We don't yet have appellate guidance on what might cabin courts' discretions to sentence now. It's likely to be an abuse of discretion standard. Is the one that is likely to be adopted, but is it going to emphasize logical sentencing, evidence-based sentencing, and so forth? So we're at the start of looking at what the status quo really is. We've got some concerns, and we've got some good signs. And let me just mention lower terms. I know you asked about upper terms, and I mentioned there's a 1% uptick. It seems to be that, as Judge Cousins said, it seems to be that we're still going on evidence-based sentencing, and we're still using those main factors. Lower terms, this is the first time I've seen lower term figures, and that would be on the first page of the CDCR figures. And again, I listened to the presentation rather than do the percentages, so I don't know what the percentages are. But the two most important years to look at would be 2006 again and 2009. And I see in 2006 there were 69,400 admissions. In 2009 there were 63,600 admissions, which is a drop of about 5,800 or so. The lower terms dropped from 40,997 in 2006 to 37,426 in 2009, which is a drop of approximately 3,500. I don't know if that's a disproportionate low drop in lower terms, if this uptick in the upper terms is also going to be reflected by there's also fewer lower terms given, which is another area of concern, is how this triad is working out, and the reasons for some of these changes. We talked about Jessica's Law, which some people that may have not fallen under that type of law before now fall under it now, and what effect is that having on sentences? So we're beginning the review. I'm pleased to give the public defender's point of view, and I'm happy to answer any questions.
Thank you. Yeah, I'm very grateful. And I do want to acknowledge your recognition of the document and thank the public safety staff, particularly Ms. Hirachi, for compiling that. And one of the things I'd like the Public Safety Committee to pursue in our next session is when you mentioned Jessica's Law. I know there was a recent ruling that I think just affects L.A., but then eventually will come to the state, is looking at, for sexual offenses, the tiered approach that New York State has. So we'll be pursuing that. Mr. Gilmore.
Thank you, Mr. Chair. We're talking about numbers here, and I was looking at the information that was provided by the public defenders as well as CDCR, and there is a little bit of a discrepancy in the fourth paragraph of the public defenders. We're looking at the numbers on 2006 of 70,529 total admissions, but CDCR has it at 69,408, as well as in 09, the numbers are not, they don't coincide as well. We have 64,243 according to the public defenders in 09, and then CDCR 63,633. It just seems to me that the methodology would be a much better, that we would use like a 3-year average rather than going annually. I mean, I think it would be a much better measure of a method, if you will, of looking at the numbers. I found it very interesting as well, Mr. Chair, that that we would see both in San Francisco and Kern County, Kern, which is my district, the passage of SB 40 did not lead to an increase in upper term sentencing. I thought that was pretty interesting with San Francisco and Kern. Thank you.
I wonder if I could comment on the difference in figures, because I noticed those too. At the bottom of the page of each one of the CDCR pages, it states these data values may differ from those previously published due to database updates. So that's the likely reason for the difference. I took my figures from what was on the, because I wrote those figures. I took those figures from what was on the website at that time. I do agree that it would be a good idea to take, say, 3 years at a time. We don't yet have 3 years experience under SB 40, and maybe we'll talk about that in the next panel, but it would be a good idea to take a longer sweep if we could.
The only thing I would just say is the result would change as a result of that.
Mm-hmm. Yes. Yeah, I do think there'd be some adjustments, yeah.
Thank you very much, Mr. Byers.
Thank you.
Yes, thank you. I represent the LA County District Attorney's Office. I am one of the number 3 people in the office, and I am over what's called line operations, which is approximately 550 lawyers in the office who prosecute most of the cases that are that come out of LA County that are contained in the statistics. Our position is that the Cunningham fix, as we like to term SB 40 in certainly SB 150, appears to be fair, appears to be working, and it was a simple but I think effective solution to the Cunningham case. If I too have different statistics than are within the book, and I assume that our statistics are updated because they're higher in numbers. But given even the limitations that we've already talked about, it appears that no demonstrable or significant harm is occurring because of this fix. Judges are still doing their job and taking into account factors that have been used for years in determining what's an appropriate sentence. And of course, we realize that different cases may produce different results. But looking at the updated stats, for instance, we did do the percentages, and San Francisco in 2004 went from 27% getting that upper term to 18%. At one time, it went as low as 14%. Sacramento went from 14% down to 12%, and at one point went as low as 11%. Getting the upper term, Riverside, too, had a decrease similar to Sacramento's. San Diego stayed the same. LA County increased, but the raw numbers decreased by 1,000. There were 1,000 less people sentenced to state prison from 2004 to 2009. Same thing with Solano County. Solano County had an increase, the most significant increase of inmates getting the upper term for charges, but they had a significant decrease in admissions. In fact, the statewide decrease of admissions to state prison appears to have dropped by 1,300. And I think we have to look at that. I think that, quite frankly, people are looking for alternatives. There's, for instance, in our county, we just launched Veterans Court and similar other diversion and programs to deal with people other than using the expensive state prison alternative. But the office's position is that if you don't extend the sunset, you leave the judges without any guidance, and that's, to me, a lot more disheartening or dangerous than going ahead and leaving this where it is. What you have to remember is, if in fact this sunsets, that would mean that for all of the aggravating factors, we would be spending jury trial time, which we don't have that. It's a very spending jury trial time litigating or proving up each and every factor is very expensive. And there are some unintended consequences. For instance, jury trial instructions have to be drafted. And I'm not sure that you get any better justice that way, because jurors don't have a sense, I think, of certainly that judges do, of the perspective of looking at case after case, day after day, and having a perspective of who is, for instance, really a bad child molester and who's not as bad as, say, some other. So we strongly urge the committee to keep studying it, but to leave the sunset provision in place. I believe there's a proposal to extend to 2016, and we strongly support that and believe it's the least costly way to do it. And it appears just from the statistics alone, even with the limitations, that Armageddon has not come to the criminal justice system as a result of this.
I'm just curious about your own office and how it might determine whether to seek, the upper term, what facts might dictate the sentencing. Just
we look at the same thing the judges do. We're very familiar with the factors in aggravation and mitigation. Part of it is based on experience. Part of it is based on life experience. Part of it is based on how strong we think our case is. The victim certainly weighs into it, and how much they have been harmed by the crime. That's how we do it.
Okay. Thank you very much.
Thank you.
Committee members, any comments or questions for Ms. Lacey at this time? Okay, thank you.
Thank you.
Mr. Munko.
Good morning. My name is Stephen Munkelt. I'm a criminal law specialist and have been in practice for 30 years. I'm a board member with the California Attorneys for Criminal Justice, and really thank the chair and Assembly members Gilmore and Yamada for having us participate in this panel today.
Let me throw one thing at you in your presentation. I am interested in your assessment of any constitutional issues that might revolve around SB 40.
That's where I'm starting off.
Okay.
And I'm going to do that by going back to what Judge Cousins told us, because I'm delighted to hear that judges are still being trained to look at the evidence before them about the crime and the defendant in order to use their discretion in choosing between the terms. The problem is that's exactly why Cunningham held our previous version of the statute unconstitutional, because judges are making factual findings. Now we changed the language about it in the statute. We now call it a discretionary choice, and we say we're considering facts instead of finding facts. But that's just changing the words. The process that's going on is exactly the same. And what's happening is that we have taken away from the jury the opportunity to decide what the maximum term is that the defendant shall face. The real problem beyond that is that because we removed the presumption for the middle term, the longest term that's authorized by the jury verdict, the maximum term for the Cunningham or constitutional purpose, is now the low term, because the judge has to consider the facts in order to impose either the middle term or the upper term. So in our view, not only is the SB 40 language simply papering over the problem and not actually addressing the constitutional defect, but it also creates a problem where we believe sooner or later some court, whether in California or in the federal side, is going to say this is unconstitutional, and everybody's term that's above the low term is going to have to be reconsidered and reevaluated, and we're going to do something else with it. So we're building in a time bomb. I'm making this argument in every felony sentencing I do where a prison term is likely to be imposed. There are other attorneys in the state doing the same thing. So, as you are well aware, it's a large system, and it takes time for issues to get addressed and come through the system to where you get an appellate level decision. But we think that's eventually going to happen. On the other hand, if you look at SB 40 as having solved the constitutional problem, what that means is that the judge is using his sound discretion by just looking at the facts and never has to make a call, never has to make a finding, and that's what would make it constitutional. Well, if that's the case, you basically have the judge exercising some discretion without the ability to review that exercise of discretion, because there's no standard. Even if the judge in his own mind is using evidence-based process, we're saying it doesn't make any difference how that process turns out. So, for example, you could get a judge in San Diego with a 20-year-old with a drug problem who's got a residential burglary conviction. And he says the drug problem mitigates the seriousness. I'm going to give him 2 years, the low term. And you've got a judge in San Bernardino who's got a 20-year-old with a drug problem and similar situation. And he says, the drug problem really makes it aggravated because that's a persistent problem. People can't solve that. So I'm going to give him the upper term. And both sentences would stand, because even though they're considering facts, there's no way to review them or decide, was this a fair use of those facts or not? So SB 40 can be interpreted one of two ways. Either it still violates the Constitution because judges are using facts to make their decision, and those facts can be reviewed, and they've taken the power away from the jury for every decision above low term, or you've got an unreviewable discretion of the judge, which, whatever the statistics may be today, certainly builds into the system the potential for the same kinds of abuses which statistically developed under the previous indeterminate law, where over time racial and ethnic biases, sexual preference issues, all those things come into play in sentencing statistically, so that you end up with an unbalanced system that doesn't meet the goals of balanced perspective and fairness that Judge Cousins specifically would like to see. As a very brief aside, CACJ believes that a sentencing commission is necessary in the long term to really address these issues in a more broad scope way. But on the specific SB 40 issue, we think what needs to be done is we actually have to fix the constitutional problem.
Yeah, I would just so I clear it. I think what you're arguing about the constitutionality is that it's particularly pertinent to the lower term,
yes,
because that's the maximum
Yeah, the language from Cunningham was, quoting Blakely, was that if the jury's verdict alone does not authorize the sentence, if instead the judge must find an additional fact to impose a longer term, then the Sixth Amendment is violated. And so if we've got this triad and we say, okay, the low term, you don't have to give any reason for that because that's a low term, that's a maximum. If the judge is using his discretion to say, I think this case, because of certain facts, deserves the middle term, then he has used facts in addition to what the jury considered, and he's violating the Sixth Amendment. The statistics.
Mr. Gilmore.
Thank you, Mr. Chair. Pretty interesting. My experience has been on the Public Safety Committee that oftentimes on bills, when we hear from the defense side of a particular issue, we're wanting the judges to have discretion.
And that's why I say in long term we favor a sentencing commission to decide how to do that in a fair way. But with the triad system, just fixing this one little piece of it, what we've ended up with is a discretion that cannot be reviewed, and that's not a good thing.
I just wanted to say that.
Sure.
With regard to the sentencing commission, the district attorney's office position is that we're not in favor of sentencing commissions if they're going to be fixing terms for sentences. We believe that the legislature has done a good job of that. I think that if there was a commission just to study whether there's been fairness, that's one thing. But we think that for instance, the feds have a sentencing commission, and we just see limited value with that. Thank you.
Thank you. Ms. Yamada?
Yes. Actually, I'm not sure if this is directed at any one of you, maybe all of you, but I will maybe turn to Ms. Lacey first. You know, what I've heard thus far is that we are faced with issues of cost of administration of justice almost versus the administration of justice. And would it be the position of the LADA's office that, it's more heavily weighted towards looking at the costs of administration of justice for these jury trials, essentially, that are obviated now by the current situation? This is not to question the merits of the judges that have been working diligently under the current system. The question of administration of justice, the cost of justice, and whether justice is served are very clearly different in my mind. And I don't think that we should ever assign a cost to seeking justice. It's never too late to seek justice. Right. So I wanted to know if you could clarify, because I heard a little bit of that in your remarks.
Sure. I agree with you in the sense that if we're talking about a defendant's constitutional right, the cost of it is irrelevant. Where cost becomes an issue in the criminal justice system is that we don't have unlimited resources. I don't have unlimited lawyers. We don't have unlimited judges and money. And so if there are two solutions where the Constitution is not violated, it seems to me you would take the less costly solution. What we've said is we're looking at the statistics, and it appears that there is no meaningful increase of people going to jail for a significant amount of time, more than when the old system was in place. And so we're saying that it appears that SB 40, and you have to excuse me, I have a head cold and flew up this morning, and I'm still in that bubble you get sometimes when you land, and so I can barely hear my own voice. But and I'd say that as a disclaimer. I think that when you have two solutions that are fair, then it makes sense to take the one that's less costly. With the sentencing commission, no offense, the phrase I always use when we talk about putting together a committee and to study things is that in my life, I always say, God so loved the world that he didn't send a committee to save it, that he sent one guy. You know what I mean? And I use
Well, in
that,
her I trust.
Yes, yes. And I use that because so often I have been on committees where we've solved nothing. We've gone nowhere. We've sat in rooms and, we haven't been in, most of us haven't been in courtrooms in 20 years, and so we haven't come up with meaningful solutions. Sometimes you get on a committee and they solve things right away. That's my fear about the Sentencing Commission. So, no, I agree with you. Justice shouldn't have a cost. I want a fair trial just as much as my counterparts on this thing, because I want the verdict to stand. So,
Okay,
thank you.
Thank you. Any other comments or questions? All right, listen, thank you very much, Judge. We're going to excuse you, and your presentation was valuable. So, and I commute your sentence. And I've always wanted to say that. And we're going to be joined by Mr. Adachi. Is that correct? For our last panel. And this is alternative proposals. And we're familiar with the three other panelists. And Mr. Adachi is the public defender of the city and county of San Francisco, a small town on the coast. You may have heard of. Welcome.
Where is...
Nice to see you.
Great to be here.
Would you like to start?
Absolutely. Thank you, Mr. Chair. SB 40. I was here in, I think it was March of 2007 when the hearings were initiated regarding this, and it was sold to the Assembly and then to the Senate as a short-term fix, something to deal with the Supreme Court's decision as a Band-Aid in order to give the legislature an opportunity to address the many issues raised by Cunningham and other decisions. Fast forward 3.5 years later, and we still have no solution. So the question is whether we continue a short-term fix that is defective for two reasons. One, on the question of constitutionality, the right to a jury trial, of course, is one of the most sacred rights that we enjoy in this country. The founders of this country enacted the Sixth Amendment to ensure against the arbitrary exercise of power. And that's what SB 40 allows. Because what it does, in essence, is it alters a critical component of California's sentencing scheme, namely that the presumption that the midterm is the appropriate sentencing term in the absence of aggravating or mitigating factors is no longer true. SB 40 allows the three terms to essentially be arranged without any presumption, meaning that a person could be sentenced to any of those three sentences in the absence of factual findings by a jury, which is required by Cunningham. And so a defendant in a criminal case can be sentenced to the upper term even in the absence of any aggravating factors. You know, that's not a mere change to the way a trial is conducted. This is a substantive increase in the exposure that a defendant faces for the commission of a crime. Now, if you look at the language in Cunningham, it could not be more clear than this. This court has repeatedly held that under the Sixth Amendment, any fact that exposes a defendant to a greater potential sentence must be found by a jury, not a judge, and established beyond a reasonable doubt, not merely by a preponderance of the evidence. Now, the two arguments that I hear made today is, well, it's too expensive. Well, for one, the prosecutor has the discretion to decide whether to seek an aggravated term, and if so, they can plead and prove. This is done routinely in other cases where there are enhancements or other facts that have to be found by a jury before a sentence can be imposed. We do this all the time. Secondly, the number of jury trials compared to the number of criminal cases, particularly those where the aggravated term is awarded, is very small. And I think that's borne out by the statistics that you see here. So we're not talking about an overwhelming burden in order to afford the right to a jury trial as required by the U.S. Supreme Court. The other question as to whether or not there's a pattern of awarding the aggravated term due to SB 40 will never be established. Why? Because for the most part, these cases are different. Every case is like a snowflake and is unique. But beyond that, you cannot presume from the statistics that we've seen, and clearly there's a trend showing an increase given the total number of cases of aggravated sentences, as there is a decrease in mitigated sentences. And that's something we've seen in San Francisco, is that the judges are more likely to give a midterm rather than a mitigated term. Why? Because in my experience, most judges just don't want to get reversed. And so they see that as an easy way not to get reversed. And that's not right. I mean, you mentioned the Meserly case. The one question that people are asking is why? Why, was the officer awarded the sentence that he was given? And it really goes to the question of both consistency as well as accountability, right? Because if you have a record, and I understand Judge Cousins are saying, trust us, judges, we're going to do evidence-based sentencing. How do we know that? How do we know that a judge is not going to act? And I've experienced this in San Francisco, where we have some judges who, if you commit a crime in the Tenderloin, for example, they will give you an aggravated term because it's part of sending a message to the community. And again, without that consistency reflected in the findings of a jury, you're always going to run the risk of tyranny. And that's the bottom line. I mean, could a court say it finds no mitigation but just give the low term anyway? Isn't that what happened in Meserly?
The plead and prove and the perception that it costs too much and takes too much time. Of course, if we had pension reform, maybe we could find the money. But what did you? So you were saying that happens anyway, that the prosecutor can ask for that. There wouldn't be that gap, or
right? I mean,
I agree. We shouldn't nickel dime. A person's right to
right. I mean, today there are so many enhancements, thanks to you in part, not you personally, but there's a tremendous number of enhancements in every case, and those enhancements have to be found in general beyond a reasonable doubt. I mean, think about even petty theft with the prior or the truth of a prior conviction. Those things under state law are entitled to a jury trial. So it's really no different. So if there is, and any of these facts here, that are cited in Judge Cousins' presentation, these are all facts. Crime involving great violence. Defendant took advantage of trust. Defendant was a leader and induced others. Record, lengthy, and increasing seriousness. These are all facts that have to be determined, that both sides should have a right to present evidence on, and that a jury should decide, not a judge.
Thank you. Mr. Byers, any
Thank
additional
you.
comments?
Thank you again. Yes, it might be a good idea to start with a review of enhancements and rules of court. It might also speak a little more to the question that you asked me about how the judges decide on the aggravated terms. As Jeff Adachi has pointed out, there's really two ways to increase a sentence in California. As Judge Cousins started, every crime has a triad. Every felony crime has a triad. The mitigator, the lower term, the middle term, and the upper term, or the aggravated term. And the choice among the triad is decided by the sentencing rules of court, which list a number of aggravating factors, such as was the person a leader, did the person inflict unjustifiable pain, that sort of thing, or mitigating factors. Was the person a mere follower? Did the person take care to avoid extra harm? And so forth. But there's also a number and an increasing number of enhancements. Those are statutory factors. The classic one is use of a weapon, but there are several others. Was the amount taken over $100,000? Was there a very large quantity of drugs? And those are submitted to the jury. So there's both of those. In terms of alternatives to SB 40, the California Public Defenders Association has not taken a position on what might be the best alternative, or should it be SB 40, or should there be an alternative, because we do think that there should be a review, whether it's by a formal sentencing commission or in some other fashion. We do think there should be a review. One of the things that Ms. Lacey said, I think, underscores the need for a review. Ms. Lacey said that she thinks that SB 40 is working very well. It's a good fix. And she pointed out that in some large urban areas like San Francisco and Los Angeles, the number of aggravated sentences, and I presume she also means the percentage of aggravated sentences, has gone down. And as she said that, I wondered about some of those smaller counties. Fresno County, my county, for example. I don't have statistics, but we know that the percentage of aggravated sentences has gone up by 1%. If it's gone down in Los Angeles and San Francisco and other places, it's a fair inference that it went up in other places. And one of the points to the fact-based system is it provides for some uniformity. And that's something that I think a sentencing commission should look at, is uniformity. So now, in terms of SB 40 and alternatives to SB 40, there's actually a number of possibilities. I think there's only two that are probably realistic for California. We could return to the old indeterminate sentencing law. I don't think California is going to do that. I certainly don't recommend that. We could have juries completely decide the sentences. Again, I don't think California is going to do that. I don't recommend that. We could have a single sentence for everything. I don't think we're going to do that. I think the realistic possibilities for California are SB 40 or an SB 40-like system, or what Mr. Munkelt is urging, which is a plead and prove aggravating factors system. Let me talk briefly about each one of those. So far, SB 40 is not causing obvious dramatic problems, but I've raised some concerns. The uptick in aggravated sentences may increase as newer judges come on board and exercise their discretion. They may realize they have a greater amount of discretion than they realize so far. This is what Mr. Adachi has emphasized. It may be possible to change SB 40 so that there's some encouragement given to the middle term. Originally, before SB 40, the middle term was the presumptive term. That's why the U.S. Supreme Court found the system unconstitutional, because it meant that the court under the old system had to find facts that the jury didn't find to get to an aggravated term, and often did.
And it was least vulnerable to a reversal?
Yes. But there may be some method that would be constitutional to encourage courts to give the middle term without encroaching on a person's jury trial rights. That's something that perhaps the committee might look at.
Just a comment. You made mention about the uptick.
Yes.
And we discussed earlier about that the data not being. We're having conflicting numbers in the data, and we both agreed that probably a 3-year average would be better than a single year. So I think we need to be comparing apples to apples here.
But we do need to compare them. I don't think that we should say, with all due respect to the L.A. District Attorney's position, I don't think we'd say, it seems like it's working fine, so let's do it. I think we should study it, as you point out, whether it's 3 years, 5 years, 2 years, whatever's available. I think we should take a more studied look before we jump.
I agree with that. A 3 to a 5 year average would be much better than on a single year, where we're just kind of cherry picking years, if you will.
Well, I've got some thoughts about that, but let me just sort of stick to the order that I'm going in, which is to take a quick look at pleading and proving aggravators. The current California system was the DSL, the Determinate Sentencing Law, was crafted with judge fact-finding in mind for this triad, for the aggravating and mitigating factors. And it will not translate smoothly. We can't just say, okay, we'll take all the aggravating factors and all the mitigating factors in the rules of court, and now we'll just say, now you decide them, juries. It won't translate smoothly. The California Supreme Court has pointed that out in a case called Sandoval. Just to take a couple of examples, some of the listed rules of court on aggravating or aggravating factors are really things that require people who are very familiar with the criminal law. For instance, one of the aggravating factors is that a crime was done with sophistication. Well, you have to be pretty familiar with criminology, with criminal laws, you have to see hundreds of situations before you can really say this was done with sophistication. Another one, the crime was done with great callousness. Well, any crime done to me is done with callousness. And it'd be risky to give that to a jury. You'd end up with experts on both sides. The prosecution would say, would hire an expert to inform the jury that a crime was done with callousness. The defense would hire an expert to inform the jury this wasn't a particularly callous crime. So in order to plead and prove aggravating factors, it would be necessary to recraft the determinate sentencing law. That may be desirable. The public defenders haven't taken a position on that. It may be desirable. I just think a committee needs to know that that kind of thing has to be done. Another point, in a plead and prove aggravators, it's aggravation that needs to be pled and proved beyond a reasonable doubt. Mitigating factors, either we have to start with a presumptive low term, which I think maybe Mr. Munkel's position, CACJ's position, and that's fine to start with a presumptive low term, and only if aggravators are proved do you even get to the middle term. But if you start with a presumptive middle term, the defense constitutionally would need to be able to prove mitigators by less than beyond a reasonable doubt, by preponderance of the evidence or by an even lower standard. And we also have some practical difficulties. At sentencing these days, one of the most common sentencing things that's done at sentences these days, felony sentences, is character references are brought in, or victims' letters are brought in. And Marcy's law, which was enacted as an initiative, encourages those. And the defense brings in, as I said, letters. Well, do those have to be proven beyond a reasonable doubt? Do we have to bring in all these people? So that kind of thing needs to be dealt with also with a plead and prove aggravating factors. I think a sentencing commission is needed to take a close look at these. The sentencing commission should have all the players and be fairly neutral: judicial, defense, prosecution, probation, corrections, those sorts of things. Should be done on that, and they can take a closer look at the factors that are important
Mr. Byers,
to Mr. Gilmore.
I'm going to jump in here and
Okay.
Thank you. And
Thank you.
give Ms. Lacey her turn at bat. Somehow we got two PDs, and
Yes.
there you go.
My goal was to get them fighting against each other.
Yeah, but it didn't work.
Happen. Well, I think, I've heard a lot of ideas, but not a really good alternative. And I'm not at all saying that there may not be a better fix than the SB 40. But what I think you do need to deal with, because all of these issues that even Mr. Byers has expressed take a lot of time. I don't think we have enough data. And so our position is maybe we need to give it till 2016 and look at a lot more data. I'd be hard-pressed to say that everything here is something that's going to continue. The percentage of uptick, if you will, is 15.2% in 2006 got the upper term compared to 16%. And it's notwithstanding the Attorney General's race that's going on now, that's not a significant amount of an uptick. I do think that there does need to be more time to look. You know, the judges, I've never seen them give, and I still think that's probably true now, give a sentence without giving a reason. They may not make findings that there factors in aggravation, but normally they explain why they're giving it. It seems to me that makes enough of a record for an appeal that Mr. Monkelt was talking about, that would give you enough to, in other words, to appeal a discretion. But our position is that, you know, the criminal justice system, at least in the next few years, needs some certainty. SB 40 has provided it, and we would, you know, once again ask for an extension until a better alternative comes along.
Thank you. Mr. Monkelt, do you want to wrap up, and then we'll see if there's any questions or any public comment?
Thank you very much. We need a system that preserves the role of the jury as fact finders in our criminal trials. And Mr. Adachi and CSJ have both indicated that SB 40 doesn't do that, and in a way that may eventually lead to real problems, as it could be held unconstitutional. We need a system that reserves the upper term for the worst offenders and the worst crimes. And we need to make sure that defendants have the opportunity to have a meaningful record of the factors used at sentencing, facts or consideration or whatever we call that. We need to make sure that defendants have a fair opportunity to have those decisions and their points reviewed on appeal to ensure that the consistency, which is one of the goals of the system, is actually a real thing. We don't have to reinvent the wheel. In Cunningham, the U.S. Supreme Court referred to several other states that had already adopted a plead and prove requirement. Kansas went to a system in 2005, even before Cunningham, where aggravating factors must be submitted to a jury and proved beyond a reasonable doubt. Washington, after Blakely, amended its system to provide for aggravators to be proven to the jury beyond a reasonable doubt. Minnesota, Oregon, Arizona, Alaska, Colorado, all of those states have gone to some version of proving the aggravating factors to the jury, and none of them, either anecdotally or in any of the academic information that I've reviewed, has indicated any problem of greatly increased costs or time. One of the anecdotal comments from a prosecutor in Minnesota was it adds about an hour to the average 3-day trial. That is not a huge investment to make sure that the jury is fulfilling its constitutional role. And I'm admittedly not a great fan of statistics, but I can see that the statistics you have to work with today are really not solid enough to be making decisions based on those alone. So I'm hoping that as this committee and the members decide whether they want to move forward with something other than SB 40, that you really keep in mind that we do want to preserve the jury as the fact finder, and that it is not that expensive or difficult to add aggravating factors to that list of things which already have to be proven to the jury and get their individual decision. And that includes things like, you know, was there use of a gun? Was there taking of over $50,000? There's all kinds of factual things that are done as enhancements and proven to the jury. We already know how to do it. It hasn't disrupted the system. It hasn't broken the bank in California. At least that part of it hasn't broken the bank. And we'd ask you to move forward with a really good look at a plead and prove requirement, to use our shorthand.
Thank you very much. Members? Shimada, Mr. Gilmore?
Yes, thank you, Mr. Chairman. I did want to share a few comments since I wanted to first thank you for allowing me to join you today. I'm a guest on public safety. I'm not a member of public safety. However, having been involved in bringing this discussion forward as the author of the one-year sunset extension, I felt some sense of responsibility, aside from my general sense of responsibility in always seeking justice, as we all are in this room, joined by that common bond. I certainly would go on record, if it wasn't known before, that I certainly support a sentencing commission. I think that it's important for a state as large and complex and diverse across so many values and so many systems as California is, it's important to take a look on a holistic basis. What exactly are we doing? How much is it costing? And what results is it really achieving? And I think both personally and professionally, we can all look at various verdicts that have been issued and sentences related to those verdicts that cause us to sometimes scratch our head in wonder. And I think a sentencing commission would go a long way, I think, towards, at least in my mind, reestablishing and restoring confidence, the public trust in how we operate and administer and enforce the law in California. So in whatever way that we can continue this discussion, I know that our office would be very interested in participating. But, just to sort of summarize, I think that we do have to take a look at really the root causes of why we're addressing repeat offenders, for example. And my good colleague, Mr. Gilmore, and I, we're going to miss him around here. I'm glad to see that he was able to join us today. But, looking at these statistics, this one sheet, for example, is just, just a page, but it represents, out of many thousands of individuals that are incarcerated, and but every one of them has a story. And I think we need to take a look at why we have sheets like this. These are real people. The other comment I'd like to make, and perhaps in follow-up, again, we thank CDCR for providing these very global statistics, but I'd like to see a little bit more detail. Perhaps going forward, I'd like to know race, gender, income, ethnicity, region, etc. I don't know if that was part of the original requirement, and I know those come with some costs. But these data, again, I have a little difficulty having an understanding or confidence in what does this really mean. Because, you talk about an uptick of 1% or a reduction of 1%. That doesn't say a lot to me. I'd like to have a little bit more information. So with that, I want to thank you, Mr. Chairman, for including me in this hearing today.
Thank you. And is there any public comment on this matter before I make my closing remarks? Want to approach the mic?
Mr. Chairman, members, Corey Salzillo on behalf of the California District Attorneys Association. We'd echo the remarks of the Los Angeles District Attorney's Office. We support the Cunningham fix that's been embodied in SB 40 and its subsequent legislation. As we've talked about, there's such a small variation year to year in increases and decreases in upper terms, same with the lower term, county from county. It's necessarily a factor of who commits what crimes in what year. I mean, some years you're going to have more murders than you are others, and some years you're going to have fewer 211s than you are others. So there's going to be variation, and to talk about whether or not things have materialized, it's just there's necessarily a different universe every year. The claims of huge increases in upper terms that were thrown around during the SB 40 discussions have never materialized. It's only been 3 years, but we haven't seen anything close to a huge jump in upper terms. Clearly, the decision in Cunningham allows the system that California has adopted, and I would read that, quote, other states have chosen to permit judges genuinely to, quote, exercise broad discretion within a statutory range, which, quote, everyone agrees encounters no Sixth Amendment shoal. There's no good reason that's been presented thus far to change what we're doing now. Thank you.
Thank you, sir. Next commenter.
Liberty Sanchez on behalf of the California Public Defenders Association. You have in your possession a brief one-page handout which clarifies the California Public Defenders Association position. I just want to make absolutely clear we believe the 1% uptick that we have gleaned from the CDCR data is representative of a disconcerting increase. We believe that SB 40 was never intended to be a permanent fix. We believe any uptick is not comporting with what we want to see as a constitutional response to Cunningham, and therefore we strongly urge the committee if there are continued sunset extensions brought before it this year or a permanent implementation of Cunningham, to reject those soundly. Thank you.
Thank you. Any other further comment? All right, seeing none, I do want to thank all our panelists for different shadings. We can all agree that we need sentencing reform and a sentencing commission, but what that sentencing commission looks like is where the bloodshed begins. But this has been a great start, and I really do want to salute my fellow committee member, Mr. Gilmore. He's brought a lot to this committee. This is his last meeting. And as Ms. Yamada said, we are going to miss him. He's going to be leaving the Assembly. I don't think I'll ever look at a California Highway Patrolman without thinking about him. He's certainly been an edifying presence for me in the Assembly, and I thank you very, very much. And I know your family's going to be happy to get you back.
Thank you, Mr. Chair, and it has truly been an honor and a privilege to serve in the state legislature and certainly on the Public Safety Committee. God bless you all. God bless the United States of America. It's been an honor.
Okay, well put, and the meeting is adjourned.
Nice meeting you.